Dear students, I welcome you to yet another lecture on corporate law. The theme of today's lecture is winding up. We shall in this lecture be specifically dealing with winding up by the National Company Law Tribunal. We shall also try and understand the meaning of the term winding up. Winding up is a term commonly associated with the ending of the company's existence. In fact, winding up is a process by which the assets of the company are collected and realized, its liabilities discharged, and the net surplus, if any, is distributed in accordance with the Articles of Association of the company. Professor L.C.B. Grover has defined winding up of a company as, and I quote, a process whereby its life is ended and its property administered for the benefit of its creditors and members. An administrator called a liquidator is appointed who takes control of the company, collects its assets, pays its debts, and finally distributes any surplus among the members in accordance with their rights. Unquote. Dear students, there are two modes of winding up as prescribed under the Companies Act 2013. Section 270 says that the two types of winding up are number one, winding up by the National Company Law Tribunal, and second is voluntary winding up. In this lecture, we shall be specifically dealing with winding up by the National Company Law Tribunal. Winding up by the National Company Law Tribunal is also known as compulsory winding up of a company. It is initiated by an application by way of petition to the tribunal for a winding up order. The circumstances under which a company may be wound up by the tribunal in its discretion to order the winding up of a company are stated in section 271 of the Companies Act 2013. They are number one, inability to pay debts. Firstly, a company may be ordered to be wound up if it is unable to pay its debts. A company is deemed to be unable to pay its debts if a creditor for an amount exceeding 1 lakh rupees does not get his money back within 21 days, that means 3 weeks after it fell due, and the creditor is entitled to make a petition to the National Company Law Tribunal for an order of winding up of the company. The debt, however, must be really due and not under dispute. Where a financially sound company disputed the claim on bona fide grounds that was held not to be a neglect to pay, and the tribunal refused to make an order for winding up of the company. The tribunal does not allow this remedy to be used as a shortcut or a cheap device to coerce payment of a disputed debt. The power is discretionary. The Supreme Court pointed out in Madhusudan Gordon Das and Company versus Madhu Woolen Industries Private Limited that in the exercise of its discretion, the tribunal can take all the relevant factors into account, including the wishes of the creditors, the benefit that will accrue to the petitioners, and the nature of the debt. Secondly, a company is unable to pay its debt if execution or any other process issued on a decree against the company is returned unsatisfied in whole or in part. Lastly, if the tribunal is satisfied that the company is unable to pay its debts, that is, the company is commercially insolvent. In Krishnam Sethi Basav Rao versus Kubashi Machine Tools Private Limited, the Andhra Pradesh High Court held that the order of winding up, besides being discretionary, has to be resorted as a last measure when it is in the interest of not only the company but also the public. In the instant case, the court declined to exercise such discretion in favour of the petitioners who had come up before the court with the ulterior motive and not in the interest of the industrial unit, and were seeking winding up of the unit. In Jagdamba Polymers Limited versus Neosac Limited, the Tribunal of Madhya Pradesh observed that there is a rule of caution not to entertain petitions of winding up unless a very strong prima facie case is made out on the facts, else it affects the very existence of the company in the commercial market. It will be too disastrous for any running company to suffer an order of winding up for non-payment of debt, and that too when it has certain bona fide reasons not to pay the debt. In Global Polymers and Impex Limited versus Dhananjit Apps Denmark, the tribunal observed that the winding up of a company is not a matter of right, but it is a discretionary remedy. The proper course for recovery of amount of debt is to file a civil suit. Hence, the tribunal could not convert proceedings of winding up into proceedings for recovery. If there is a reasonable prospect of resurrection and revival of a company and its effective and commercially successful functioning, the tribunal may not pass a winding up order. However, there may be instances where winding up may be a more effective way of settlement for the creditors and even the shareholders to recover whatever could be salvaged from the assets of the company. That will be so in the case of companies whose continuance would not be commercially viable and may result in incurring further commitments by way of avoidable overheads. In such a case, there would be no purpose in trying to keep alive the company and allow it to continue its uneconomic functioning. That will only result in creating further liabilities against the company, necessarily causing corresponding reduction in distributive assets. It must, however, be noted that the tribunal is not expected to direct continuance of the functioning of company in each and every case. The matter has to be decided applying the tests. Number one, whether the continuance of the functioning of the company would be in the best interest of the creditors. Number two, whether revival and resurrection of the company would be possible, especially taking into consideration the circumstances such as the degree of insolvency, likelihood of confidence of customers in view of its past performance, etc. Number three, whether the continued functioning would not result in reducing the reliable assets but would enable the company to function normally and economically. If there is a scheme before the tribunal and whether it could be implemented and feasibility of its success. If resurrection is proposed, the initial outlay and recurring expenditure on that account and the availability of resources for the same, and whether such recommencement of business of the company is likely to further reduce the distributable assets of the company. In Dr. Pritch Machines and Powders Private Limited versus Octahedron Super Abrasives Private Limited, the petitioners filed a suit against respondent for his failure to pay the debt under Section 394 of the Companies Act 1956. But the High Court of Delhi dismissed the petition as no case was made out against the respondent company. The evidence on record showed that the respondent had issued post-dated checks in favor of the petitioner, which were never encashed by the petitioner, and no explanation was given as to why these checks were not presented. Petitioner's reluctance and failure to encash the checks of the respondent company, and moreover the alleged debt was not debt and the respondent company had disputed the claim of the petitioner company. Therefore, there was no merit in the case and the High Court rightly declined to entertain petition for winding up under Section 433 of the Companies Act 1956. From this analysis, it may be summed that the inability to pay debts on the part of the company is a usual ground for filing the petition for winding up of the company. However, every debt cannot be a ground for winding up of the company. A company may be wound up on the ground of being unable to pay its debts only when certain conditions exist. These are: the amount of debt exceeds 1 lakh rupees, the sum must be definite, presently payable, and there should be no bona fide dispute about the debt. The creditor makes a written demand of payment. The demand is signed by the creditor or his agent or his legal advisor duly authorized on this behalf. The demand has been served by causing it to be delivered at the registered office by registered post or otherwise, and the company must have neglected to pay the sum demanded or to secure or compound the same to the satisfaction of the creditor for 3 weeks. Dear students, the next ground for winding up is special resolution. A company may be wound up by an order of the tribunal if a special resolution for its winding up has been passed by the company. The tribunal is, however, not bound to order winding up simply because the company has so resolved. The power of the tribunal being discretionary, it may not be exercised if the winding up is opposite to public interest or the interest of the company. It must be pointed out that the winding up by a special resolution is not a common occurrence because of the fact that companies generally have a very large number of shareholders, and if they want the company to be wound up, they would prefer its voluntary winding up, which is comparatively cheaper and less time consuming. It is quite often noticed that the companies which are in very bad financial position and confronted with the problem of income tax or sales tax defaults, protracted litigation with creditors and prosecution by the registrar of companies, etc., prefer compulsory winding up by the tribunal by passing special resolution so that all these problems are passed on to the official liquidator and the company's burden is considerably reduced. The third ground for winding up is where the company has acted against national interest. The tribunal has the power under Section 271, Clause C of the Companies Act 2013 if it is found that the company has acted against the interests of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality. The next ground for winding up is winding up of sick companies. Where a demand is made by more than 50% of secured creditors and they apply to the National Company Law Tribunal for the winding up of the company with relevant evidence for its failure to offer security or compound the debt, the company may pass an order for winding up of the company under Chapter 19 of the Companies Act 2013, which relates to revival and rehabilitation of sick companies. The next ground is winding up on an application made by the registrar. If an application is made by the registrar of companies or any other person authorized by the central government by notification under the Companies Act, the tribunal is of the opinion that the affairs of the company have been conducted in a fraudulent manner or the company has been formed for a fraudulent or unlawful purpose or persons concerned in the formation or management of its affairs have been guilty of fraud, misfeasance or misconduct in connection therewith, and that it is proper that the company may be wound up. Default of a company in filing with the registrar its financial statements. Where the company has made default in filing with the registrar its financial statements or annual returns for immediately preceding 5 consecutive years, the tribunal may order the winding up of the company. Where the company has not commenced its business within 1 year from the date of its incorporation or has suspended its business for a whole year, it may be ordered to be wound up. The power of the tribunal being discretionary, it will not be exercised unless there are indications that the company has no intention to commence or continue its business. If the suspension of the business is due to some temporary or unavoidable reason, the tribunal may refuse to order winding up. Again, the petition for winding up would not be allowed if there is delay in the commencement or suspension or interruption of business is duly explained and if the tribunal is satisfied that the business could not be commenced or resumed for a valid reason. In Reserve Bank of India versus L40 FinLease Limited, a non-banking financial corporation was required to obtain registration from the Reserve Bank of India for commencement of its business, and there was rejection of the application by the RBI because of serious irregularities noticed, inspection of books and accounts which included acceptance of deposits and peculiar method adopted for unauthorized conversion of same into shares, bouncing back of a large number of checks, etc. The official liquidator was appointed as the provisional liquidator. The tribunal therefore considered its first concern to ensure that all depositors, shareholders or creditors are duly paid by the company, for which it was necessary to have complete picture in this behalf. Hence, the tribunal directed the company to file a detailed affidavit indicating the list of all the shareholders, depositors, investors, etc., whose claims were settled in the court of the Metropolitan Magistrate, and also a list of those whose claims were yet to be settled and steps taken by the Metropolitan Magistrate in this behalf. Reduction in membership below the statutory limit may also lead to winding up of a company by the tribunal. If the number of members of the company is reduced below the prescribed statutory limit, namely in case of a public company below 7 and in case of a private company below 2, the company may be ordered to be wound up. The tribunal usually does not order winding up on this ground, but leaves it to the company to go into voluntary winding up. This ground for winding up is meant to enable the member to escape personal liability for the company's debts which he would have otherwise incurred if the membership remains below the statutory minimum for more than 6 months as provided in the Companies Act 2013. The next ground for winding up is winding up under the Just and Equitable Clause. Section 433, Clause F of the Companies Act 1956 provided that the company can order up winding up of the company when it is of the opinion that it is just and equitable that it should be wound up. Similarly, Section 271, Clause 1, Subclause G of the Companies Act 2013 provides that the tribunal can order winding up of the company when the tribunal is of the opinion that it is just and equitable that the company should be wound up. It is the remedy of last resort. In this case, the tribunal has wide powers and has complete discretion to decide when it is just and equitable to order the winding up of the company. The discretionary authority of the tribunal even enables it to subject the exercise of illegal rights to equitable considerations. The discretion of the tribunal under this clause is very wide, and the courts have exercised this discretion on a variety of grounds which may be generalized into certain categories. Firstly, when there is deadlock in the management of the company, the tribunal may order winding up on just and equitable ground. This occurs when only the 2 members of the company are not on speaking terms. Mere dispute is not enough. Re-Energy Tobacco Company Limited is an illustration on this point. In this case, 2 cigarette manufacturers, W and R, who were trading separately, agreed to amalgamate their business by forming a private limited company of which they were the only shareholders and directors. They had equal voting rights and therefore their disputes were to be resolved by arbitration. But one of them dissented from the award. They became so hostile that they were not even on speaking terms with each other. Thus, there was complete deadlock and therefore the company was ordered to be wound up although its business was flourishing. The Delhi High Court in Brown Foreman Mericus Limited versus Jagjit Brown Foreman India Limited and others held that the winding up of the company under Section 271, Clause 1, Subclause G of the Companies Act 2013 is not based on any statutory measures. Instead, it essentially depends on the equitable discretion of the tribunal, for which the tribunal generally takes into consideration certain facts. These are the conduct of the petitioner, the possible effect of winding up on the concerned company, its shareholders, members, creditors, employees, etc. Whether the petitioner himself is not responsible to create a situation for winding up of the company. The tribunal is expected to invoke the provision of Clause 2 of Section 273 of the Companies Act 2013 in the rare cases and order winding up only when no better alternative is left for the parties. The second ground for winding up of the company under the Just and Equitable Clause is where the company has lost its substratum. The substratum of the company is deemed to have been lost where the subject matter of the company is gone or the main object for which the company was formed has failed to materialize. It is impossible to carry on the business of the company except at a loss, or the existing and the possible future assets are insufficient to meet the liabilities of the company. When the main object of the company has failed to materialize or its substratum has failed. This occurred when a company incorporated to work a German patent could not obtain it, or when a company's assets were seized by the creditor. Temporary acquisition or difficulty is not the same thing. The next ground for winding up under the just and equitable clause is when there is mismanagement and loss in the company. The tribunal is justified in ordering winding up of the company under the just and equitable clause where it is not possible for the company to carry on a business except at loss and there is no prospects of achieving profits. However, mere apprehension of losses on the part of the shareholders is not a ground for winding up of the company under this clause, where, due to the mismanagement in the company, its share capital is constantly decreasing and it is running into heavy losses, the tribunal may order its winding up. In Rajmundry Electric Supply Corporation Limited versus A. Nageshwar Rao, there was mismanagement in the company and most of the capital was used by the vice president of the company for his own personal use, whose group had gained majority due to the death of one of the directors of the company. The president and the shareholders could not do anything to improve the management of the company and put it on track. The company's financial position further deteriorated due to non-collection of bills of huge amount due from the company for supply of electricity. In view of these facts and circumstances, the court deemed it just and equitable to order the winding up of the company under Section 433, Clause 3 of the Companies Act 1956, which now corresponds to Section 273, Clause 1, Subclause D of the Companies Act 2013. The next ground for winding up under the just and equitable clause is when the principal or majority shareholders have adopted an aggressive or oppressive or squeezing policy towards the minority shareholders. In Dewey and Corrington Investment Private Limited versus P.K. Prathapan, a person named Prathapan who was an NRI through his mother induced Ramanujam to start a company with an initial investment of 5 lakh rupees. Prathapan, who was the main shareholder of the company, later came to know that Ramanujan convened a meeting of the board of directors of the company on October 24, 1994 and got a resolution passed that he may be allotted equity shares. Prathapan was not informed about this resolution. As a result, he lost his majority shareholding and became a minority shareholder vis-a-vis Ramanujam. Aggrieved by this, Prathapan filed a petition for winding up of the company under Section 433, Clause F, alleging that at the time of starting the company, Ramanujan had not invested any money and he was drawing huge salary as a managing director of the company without contributing to the promotion of the company's business. Ramanujan contested the winding up petition on the ground, but Prathapan, being an NRI, the petition filed by him was not maintainable. The Company Law Board, which has now been replaced by the National Company Law Tribunal, however, did not accept this plea of Ramanujan as Prathapan's name was registered as a shareholder in the shareholders' register. Allowing the petition, the Company Law Board held that it was a fit case of ordering winding up of the company under the just and equitable ground. In Sangram Singh Gaikwad versus Shanti Devi Gaikwad, the apex court held that an act which is burdensome, troublesome and wrongful may be considered as an oppressive act. In the context of a company, an act of the majority which is detrimental to the interests of the minority shareholders will be an oppressive act against which winding up orders may be issued by the tribunal. Where a director of a private company was removed only on the ground that he refused to consent to a transaction, the court held that to be an abuse of power which made it just and equitable to wind up the company. ultra-vires application of the funds and the consequent disassociation of 93% shareholders with the company and persistent refusal by a managing director to hold meetings or to pay dividends have been held to be a sufficient ground for winding up of the company. The next ground for winding up of the company under the just and equitable ground is where the company has been conceived or brought into existence fraudulently for some illegal purposes. In Universal Mutual Aid and Poor Houses Association versus A.D. Thappanaidu, the main object of the company was to conduct lottery. Therefore, the mere fact that some of its objects were philanthropic was not a sufficient ground to prevent the company being wound up, as it was mainly formed for an illegal purpose, that is, conduct of lottery. In T.E. Brinsmith and Sons, the prospectus of the company stated that it had agreed to purchase the business of an existing firm, and thus the subscribers of the company's shares were intentionally misled to believe that the firm was really a reputed concern. The company was ordered to be wound up since it was formed for a fraudulent purpose. It has been held by the Calcutta High Court in Oriental Navigation Company versus Banaram Agarwal that fraudulent misrepresentation in the prospectus will not be a sufficient ground for winding up order in India, as the majority of the shareholders can waive the fraud. Where the evidence showed that the company had inadequate records, it was a share vending company but pretended to play an advisory role for an investment purposes and was advising shareholders to purchase shares of an American company as they were not freely tradable. This was held to be an unlawful operation and against public interest. Lastly, where it is proved that an incorporated private company is in substance a partnership, it may be ordered to be wound up when there is abuse of power or breach of good faith which the partners owe to each other. In Bhaskar Stoneware Pipes Private Limited versus R. and Bhaskar, the Delhi High Court pointed out that the crux of the matter is not whether a member has been expelled or not, but whether there has been a breach of mutual faith and understanding between the parties. That parity of shareholders will be maintained, but one group attempted to take over the company by increasing its shareholding. Therefore, the company ordered the winding up of the company under the Just and Equitable Clause. The relief under the Just and Equitable Clause, that is Section 271, Clause F of the Companies Act 2013, is in the nature of last resort when other remedies are not efficaciously available to protect the general interest of the creditors and the shareholders. Therefore, the tribunal will refuse to make an order of winding up if, in its opinion, some other remedy is available to the petitioners and they are unreasonably insisting on winding up instead of pursuing the other remedy. For example, in case of oppression, misconduct or mismanagement, an alternative remedy under Section 241 being available, a petition under Section 271, Clause F for winding up shall not be normally entertained. The winding up order under Just and Equitable Clause may not be made in certain cases. These are where the company is at a loss, but there are chances of its making profits and the majority of the shareholders are against the winding up. Number two, where the directors in exercise of their powers to do so refuse to register the executors of the deceased shareholders even when this causes hardship to the shareholders. Number three, where the business of the company is temporarily suspended owing to trade depression and is intended to be resumed when conditions improve. If the just and equitable ground did not exist at the time of hearing the petition, though it might have existed at the time of presenting the petition. Dear students, we shall now discuss who may file the petition for winding up under Section 272 of the Companies Act 2013. Section 272 of the Companies Act provides that a petition for winding up of the company may be presented to the tribunal by number one, the company, number two, any creditor or creditors, including any contingent or prospective creditor or creditors, number three, any contributory or contributories, number four, all or any of the parties we mentioned, whether together or separately. Number 5, the registrar of companies, or in a case falling under section 224, that is an application for winding up following an investigation by any person authorized by the central government in that behalf, or where a company is already under voluntary liquidation or winding up by the tribunal, and such voluntary winding up cannot be continued with due regard to the interests of the creditors or contributories or both, the petition for an order of its winding up may be presented by any of the persons we just discussed or by the official liquidator as provided in section 272 of the Companies Act. Petition by the company. The company is entitled to petition when it has passed a special resolution requesting that it be wound up by the tribunal. The company's petition has to be accompanied by the statement of its affairs in such form and manner as may be prescribed. Creditor's petition. A creditor, secured or otherwise, debenture holder and a trustee for debenture holders can apply for winding up. Where a petition is brought by a contingent or a prospective creditor, the tribunal may admit it if there is prima facie case and the security for costs is given. Contributories petition. On the winding up of the company, its members are called contributories. Where the petition is filed because of the reduction in membership, any contributory can apply. When the application is founded on any other ground, it will be requisite that the number of shares in respect of which the petitioner is a contributory were originally allotted to him, or he has been the registered holder for at least 6 months during the 18 months immediately before the commencement of winding up, or the shares have devolved on him through the death of a former holder. A contributory is entitled to present a petition even if he is a holder of fully paid shares, or that the company may have no assets at all or may have no surplus assets left after satisfaction of its liabilities. The Supreme Court in 7 Trent Water Purification Incorporated versus Chloro Controls India Private Limited and another held that the person filing the petition for winding up of the company under section 439 clause 4 subclause B, which corresponds to section 272 clause 1 subclause D of the 2013 Act, must be registered as a shareholder of the company. In other words, any former shareholder of the company whose name is struck off from the register of shareholders cannot bring a petition against the company for its winding up, as he is not a contributory. The court further made it clear that section 439 clause 4 subclause B would apply only to natural persons who are holding shares in their individual capacity and not to juristic entities. This becomes evident from the word death mentioned in the statute, which refers only to natural persons. Dear students, this is all with regard to winding up by the tribunal. In today's lecture, we tried to understand what is meant by winding up of a company. We also tried to understand what is meant by compulsory winding up. We also discussed the grounds for compulsory winding up. We also discussed who are the people who can petition to the tribunal for an order of winding up. Hope you have been able to understand all that we discussed today. Stay blessed.